Tempted to snoop? You should be aware of a new Canadian cause of action. Those involved in matrimonial disputes and litigation can attest to the fact that emotions run high. Acrimony can breed one-upmanship, and ex-spouses may consider resorting to less than ethical means of obtaining information about their former partners to be used in the dispute resolution process. But however tempting it may be, it's important for an ex-spouse to resist the urge to engage in spying on the other, or to surreptitiously gather information in an unscrupulous manner. A recent Court of Appeal decision has essentially recognized a new cause of action for certain kinds of intrusions into individual privacy. In this case, the plaintiff Sandra sued her co-worker Winnie, with whom she worked at a Toronto branch of the Bank of Montreal. Sandra and her ex-husband were embroiled in a dispute over money that he owed her for child support. As it happens, Winnie had started dating Sandra's ex-husband. In an abuse of her position with the bank and contrary to the bank's policies, Winnie exploited the access she had to Sandra's personal bank account information, which included transaction details, date of birth, marital status, and address. Indeed, she looked into Sandra's banking records approximately 174 times in a 4-year period. Apparently, she said, for the purpose of checking to see whether Sandra was receiving child support payments from her ex-husband. Sandra became suspicious that her account was being monitored and complained to the bank. Upon being confronted, Winnie confessed. She was suspended for a week without pay and was denied her annual bonus. Sandra sued Winnie for invasion of privacy, claiming $90,000 in damages. After considering these facts, together with the history of privacy-related causes of action in Canadian tort law, the Court of Appeal recognized a new cause of action called intrusion into seclusion, which is essentially a subcategory of invasion of privacy. In order to establish a successful claim based on intrusion into seclusion, a person must prove 1. An unauthorized intrusion, 2. The intrusion was highly offensive to a reasonable person, 3. The matter intruded upon was private, and 4. The intrusion caused anguish and suffering. Even though there had not been a cause of action for invasion of privacy, the law has recognized similar claims for nuisance and trespass. With that in mind, the court was willing to recognize that the plaintiff Sandra had endured an unauthorized intrusion into her private affairs, which caused her to suffer some monetary damages. The court said this new cause of action, called intrusion into seclusion, only arises for deliberate and significant invasions. Damages should generally be modest. Ultimately, after taking into consideration the fact that Winnie had apologized for her conduct, the court awarded Sandra $10,000 in damages. So what does this mean if you're going through a separation or divorce? Think twice before you snoop.
Thank you for watching. If you'd like further information, or if you would like to schedule an appointment with one of our lawyers, please give us a call.